Okay, so magandang hapon po sa inyong lahat at ito na naman po ang inyong Lola Ray para sa isa na namang edisyon ng In Layman's Term. Kung saan magbabasa na naman tayo ng batas at susubukan natin hopefully kung kakayanin ko na ipaliwanag sana ng konti. So ngayon, ang babasahin po natin ngayon ay ang Civil Code. Okay, Kodigo Sibil. Okay. Sa Civil Code, matatagpuan mo yung mga topics about civil personality, citizenship and domicile, marriage, legal separation, rights and obligations between husband and wife, property relations, etc., etc., etc. So, nahati po ang Civil Code sa apat na libro. Apat na libro na may mga maraming title. Okay, so basahin muna natin yung preliminary title. Sabi rito, sinasabi niya lang na preliminary title chapter 1, Article 1. This act shall be known as the Civil Code of the Philippines. Okay? Yung batas na nagbubuo sa Civil Code of the Philippines, yun ang magiging title niya. Article 2. Sabi na rito, laws shall take effect after 15 days following the completion of their publication either in the official gazette or in a newspaper of general circulation in the Philippines unless it is otherwise provided. So bago raw mag-take ng effect yung batas, kailangan muna daw lumipas ng 15 days matapos ang completion ng kanilang publication either in the official gazette or in a newspaper of general circulation sa Pilipinas. Article 3. Sabi rito, ignorance of the law excuses no one from compliance therewith. So kahit na hindi mo alam ang batas, kung ito ay nilabag mo, hindi ka excused. Article 4. Laws shall have no retroactive effect unless the contrary is provided. So wala raw retroactive effect unless ito ay pinayagan ng batas. Article 5. Acts executed against the provisions of mandatory or prohibitory laws shall be void except when the law itself authorizes their validity. Article 6, sabi rito, rights may be waived unless the waiver is contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. Article 7, laws are repealed only by subsequent ones. O napapalitan lang sila ng mga bagong batas na ipinapasa, and their violation or non-observance shall not be excused by disuse or custom or practice to the contrary. So hanggat wala pang mga batas na napapalitan ng bago, okay, ay ito ay tuturing pa rin na gumagana. Sabi rito, when the courts declared a law to be inconsistent with the Constitution, the former shall be void and the latter shall govern. Ibig lang sabihin nito, kunwari may bagong batas, tapos dineklara ito na unconstitutional ng Korte Suprema o ng Korte, yung pinalitan niyang batas ang siyang mangingibabaw. Administrative or executive acts, orders, and regulations shall be valid only when they are not contrary to the laws of the Constitution. So, kagaya na lagi nating sinasabi, ano man yung mga executive acts o administrative orders, usually ng Pangulo, makapangyayari lamang or valid lamang kung hindi sila lumalabag sa Konstitusyon. Lahat po ay nakaangkla sa Konstitusyon. Article 8. Judicial decisions applying or interpreting the laws or the Constitution shall form part of the legal system of the Philippines. Ibig lang sabihin nito, lahat ng dinesisyonan ng Korte Suprema ay magiging bahagi ito ng legal system ng Pilipinas. So kung paano nila ito dinesisyonan, kung paano nila ini-apply yung batas, ganun na po natin i-apply ang batas. Article 9, no judge or court shall decline to render judgment by reason of the silence, obscurity, or insufficiency of the laws. Ibig lamang sabihin nito, pag may kontrobersiya, kumbaga may kaso na nasa korte, Kailangan pa ring desisyonan ito ng huwes kahit na ang batas ay silent, obscure, or hindi sapat. Ilalatag niya pa rin yung pinakasasapat na dahilan kung bakit siya nag-come up with that decision. Article 10. In case of doubt in the interpretation or application of laws, it is presumed that the lawmaking body intended right and justice to prevail. Sakaling may hindi malinaw sa batas, lagi na lamang daw tatandaan na ang magiging gabay sa interpretasyon na to ay yung kongreso o yung lawmaking body natin, ang intensyon nila ay maging babaw ang hustisya. Article 11. Customs which are contrary to law, public order, or public policy shall not be countenanced. Article 12. A custom must be proved as fact according to the rules of evidence. So yung isang custom o yung nakagawian, kailangan itong patunayan as katotohanan o totoo siyang nangyayari talaga para siya ay maging katanggap-tanggap sa rules of evidence. Article 13. When the laws speak of years, months, days, or nights, it shall be understood that years are of 365 days each, months of 30 days, days of 24 hours, and nights from sunset to sunrise. So, ganon tinitignan ng ang batas, okay? If months are designated by their name, they shall be computed by the number of days which they respectively have. In computing a period, the first day shall be excluded, and the last day included. Included. Okay. Article 14. Penal laws and those of public security and safety shall be obligatory upon all who live or sojourn in the Philippine territory, subject to the principles of public international law and to treaty stipulations. So yung mga batas, yung criminal law natin, at anumang batas na nangangasiwa sa public security at kaligtasan ng mga tao ay makapangyayari sa kahit na sino man. Hindi ka man citizen, hindi ka man taga rito, basta naririto ka sa teritoryo ng Pilipinas, ikaw ay karapat dapat lamang na sumunod sa batas. Article 15. Laws relating to family, rights and duties, or to status, condition, and legal capacity of persons are binding upon citizens of the Philippines even though living abroad. Okay? So, yung obligasyon kunwari ng isang ama na magbigay ng karampatang sustento sa kanyang mag-ina ay makapangyayari kahit pa nasa abroad ka. Article 16. Real property as well as personal property is subject to the law of the country where it is stipulated. Okay? Kasi yung real, paano naman tayo magkakaroon ng jurisdiction sa isang pag-aari na nasa ibang bansa? Wala naman ito sa teritoryo ng Pilipinas. Yun nga lamang daw. However, in intestate and testamentary successions, yung pagmamana, intestate, yung walang will, yung testamentary, yung merong will, both with respect to the order of succession and to the amount of successional rights and of the intrinsic validity of testamentary provisions shall be regulated by the national law of the person whose succession is under consideration, whatever may be the nature of the property and regardless of the country wherein said property may be found. Magtungo naman tayo sa Article 17. The forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they are executed. So, yung batas natin, pagdating sa kontrata, ay siyang mangangasiwa kung dito natin ginawa ang kontrata na yon. Diba? Kung nakipagkontrata naman tayo, nasa Amerika tayo, may kakontrata tayo doon, yung bansa na yun, yung batas ng bansang yun ang mangangasiwa. Kasi doon tayo pumasok sa kontrata doon When acts referred to are executed before the diplomatic or consular officials of the Republic of the Philippines in a foreign country, the solemnities established by Philippine laws shall be observed in their execution. So, kunwari tayo ay kinasal sa embahada ng Pilipinas abroad, yung batas ng Pilipinas ang makapangyayari. Okay? Kasi yung mga embahada, parang extension yan ng bansa natin. Okay? Prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy, and good custom shall not be rendered ineffective by laws or judgments promulgated or by determinations or conventions agreed upon in a foreign country. O basta yung mga batas na mayroong pinagbabawal na gawain ng mga tao, eh masusunod pa rin. Yun ang ibig nilang sabihin. Kasi para sa kaligtasan niya ng lahat. Article 18, in matters which are governed by the Code of Commerce and special laws, their deficiency shall be supplied by the provisions of this code. So, magiging suppletory. Okay, itong mga batas na naririto doon sa Code of Commerce. Okay. Chapter 2, Human Relations. Ito, mahalaga ito. Nasa preliminary title pa rin tayo, pero yung basically, nakalagay dito yung mga basic na dapat mong tandaan Okay, parang ganito. Chapter 2 ng preliminary title, tinatalakay niya ang human relations. Sabi rito, Article 19. Every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. Pakahalaga nito. Bawat tao raw sa kanyang exercise ng kanyang karapatan, dapat at sa kanyang performance ng kanyang mga obligasyon, dapat daw umaarte siya nang naayon sa hustisya, ibinibigay niya yung para sa nararapat, and observe honesty and good faith. Okay? Article 20. Every person who contrary to law, willfully or negligently causes damage to another, shall indemnify the latter for the same. So, sinasadya mo man o hindi, kailangan mong i-indemnify o magbayad ka ng danyos sa isang taong naperwisyo mo. Okay? Actually, yung civil code, parang Biblia rin to kung paano ka dapat sumunod o kumilos bilang tao, di ba? Actually, kung alam mo ito, marirealize mo na kaya pala bawat krimen, hindi ka lang nakukulong, kundi may karampatang danyos lagi na binabayaran. Article 21. Any person who willfully causes loss or injury to another in a manner that is contrary to morals, good customs, or public policy shall compensate the latter for the damage. Okay. Article 22. Every person who, through an act or performance by another or any other means, acquires or comes into possession of something at the expense of the latter without just or legal ground, shall return the same to him. So, kung meron na pa sa iyo na hindi naman dapat sa iyo, kailangan mo itong isoli sa kapwa mo. Okay? Yung pong mga taxi driver na nagsusoli sila ng mga nakita nila, na natagpuan nilang mga naiwang pera, wallet, sumusunod po sila rito sa provision ng Article 22. Kahit na sabihin nilang, pwede namang hindi kami mahuli, sumusunod pa rin sila sa kung paano kumilos ng tama sa isang lipunan. Article 23, even when an act or event causing damage to another's property was not due to the fault or negligence of the defendant, the latter shall be liable for indemnity if through the act or event he was benefited. So, kunwari, nakaperwisyo ka sa iba. Kunwari, may isang nangyaring perwisyo sa kapwa na hindi mo naman kasalanan. Hindi naman dahil ito sa kasalanan o kapabayaan mo. Pero nakinabang ka dahil sa perwisyong naidulot nito sa kapwa mo. Kailangan mo pa rin, liable ka pa rin sa indemnity. Kailangan mo pa rin bayaran ng danyos yung kapwa mo kasi nakinabang ka kahit na hindi mo pa kasalanan. Article 24. In all contractual property or other relations, sa kikipagkontrata mo raw, when one of the parties is at a disadvantage on account of his moral dependence, ignorance, indigence o yung kahirapan, mental weakness, tender age, or other handicap, the court must be vigilant for his protection. So ito ay duty ng mga korte na proteksyonan yung mga at a disadvantage. Okay? Article 25. Thoughtless extravagance in expenses for pleasure or display during a period of acute public want or emergency may be stopped by order of the courts at the instance of any government or private charitable institutions. So, pwede rin ipatigil ng gobyerno at ng private charitable institutions yung mga thoughtless, mga hindi pinag-isipang pagpapakita ng extravagance o luho. Diba? Papakita ka na matinding luho, may kalamidad na nga. O, diba? Article 26. Every person shall respect the dignity, personality, privacy, and peace of mind of his neighbors and other persons. The following and similar acts, though they may not constitute a criminal offense, shall produce a cause of action for damages prevention and other relief. So kahit na hindi man ito criminal offense, meron pa rin cause of action para kasuhan ka para sa danyos o para ipagutos ng korte na ipatigil itong ginagawa mo. Ito yun, number 1. Prying into the privacy of another's residence. Ito, kung di ako nagkakamali, may batas na ito. Yung anti, ano ba yun? Yung stalking. Meron na yung batas yata tayo para sa anti-stalking. Hanapin natin sa susunod. Or, basta may batas na ito. Number 2, meddling with or disturbing the private life or family relations of another. Number 3, intriguing to cause another to be alienated from his friends. Pinagkakaisahan mo yung tao para siya yung pinagtatawanan o hindi na siya samahan ng mga kaibigan niya. Number 4, vexing or humiliating another on account of his religious beliefs, lowly station in life, place of birth, physical defect, or other personal conditions. Sa madaling salita, nilalait mo, pinagtatawanan ninyo siya. Bawal yan at pwede kang kasuhan ng damages. So, tandaan nyo yan sa mga chismosa. May anti-chismosa law na rin yata na ginagawang krimen na yon. Hindi lamang magbabayad ka ng damages. Okay, so dati pa meron ng remedyo laban sa mga taong mapanira. Article 27, any person suffering material or moral loss because a public servant or employee refuses or neglects without just cause to perform his official duty may file an action for damages and other relief against the latter without prejudice to any disciplinary administrative action that may be taken. So ito palang batas na to, sinasabi niya any person na nagsuffer ng kawalan, nawalan siya ng material or moral loss dahil ang isang public servant hindi niya ginawa yung kanyang dapat na tungkulin o ginawa niya ng hindi naaayon, pwedeng kasuhan. So kung halimbawa ginulpi ka o pinagkaisahan ka, naghingi ka ng tulong sa pulis, tapos patulog-tulog lang siya, pwede siyang kasuhan, okay, ng damages. Hindi lang damages ang pwede mo makuha sa kanya, pwede pa siyang maipatanggal o masuspindi sa kanyang serbisyo. Article 28, unfair competition in agricultural, commercial, or industrial enterprises or in labor through the use of force, intimidation, deceit, machination, or any other unjust, oppressive, or high-handed method shall give rise to a right of action by the person who thereby suffers damage. Unfair competition ang sinasabi rito. Liable ka sa damages sa na-damage mo kung ikaw ay unfairly competing, di ba? Pinatay mo yung negosyo niya dahil sa iyong pagkagulang. Liable ka sa damages. Article 29. When the accused in a criminal prosecution is acquitted on the ground that his guilt has not been proved beyond reasonable doubt, a civil action for damages for the same act or omission may be instituted. Such action requires only a preponderance of evidence, period. Upon motion of the defendant, the court may require the plaintiff to file a bond to answer for damages in case the complaint should be found to be malicious. If in a criminal case a judgment of acquittal is based upon reasonable doubt, the court shall so declare in the absence of any declaration to that effect. It may be inferred from the text of the decision whether or not the acquittal is due to that ground. Okay? Article 30. When a separate civil action is brought to demand civil liability arising from a criminal offense and no criminal proceedings are instituted during the pendency of the civil case, a preponderance of evidence shall likewise be sufficient to prove the act complained of. Punta na tayo sa Article 31. When the civil action is based on an obligation not arising from the act or omission complained of as a felony, such civil action may proceed independently of the criminal proceedings and regardless of the result of the latter. Tungo tayo sa Article 32. Any public officer or employee or any private individual who directly or indirectly obstructs, defeats, violates, or in any manner impedes or impairs any of the following rights and liberties of another person shall be liable to the latter for damages. Ito, freedom of religion. Number 1, hinaharangan mo ang kanyang freedom of religion. Number 2, freedom of speech. Number 3, freedom to write for the press or to maintain a periodical publication. Number 4, freedom from arbitrary or illegal detention. Number 5, yung arbitrary or illegal detention po ay isang krimen, ha. Number 5, freedom of suffrage o yung pag-alis mo sa biyahe-biyahe mo. Ay, sorry. Sa fridge pagboto mo. Yung kinikitil niya yung kalayaan bumoto. Number 6, the right against deprivation of property without due process of law. Number 7, the right to adjust compensation when a private property is taken for public use. O ginamit ng gobyerno yung kanilang power of eminent domain, magpapalawak sila ng kalsada, tapos nagiba yung bakod o bahay mo, hindi ka man lang binayaran. Number 8, the right to the equal protection of the laws. Number 9, the right to be secure in one's person, house, papers, and effects against unreasonable searches and seizures. Number 10, the liberty of abode and of changing the same. Number 11, the privacy of communication and correspondence. Nakalagay ito sa Bill of Rights. Ito mga to Number 12, the right to become a member of associations or societies for purposes not contrary to law. So, pwede kang mapabilang na maging member ng isang asosasyon o grupo basta hindi ito labag sa batas. Number 13, the right to take part in a peaceable assembly to petition the government for redress of grievances. Ibig sabihin, may karapatan ka maging aktivista. Huwag ka nga lamang mapanira. Number 14, the right to be free from involuntary servitude in any form. Number 15, the right of the accused against o laban sa excessive bail, laban sa masyadong mataas na piyansa. Number 16, the right of the accused to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy and public trial, to meet the witnesses face to face, and to have compulsory process to secure the attendance of witness in his behalf. Nakalagay rin yata yan, kung di ka nagkakamali, sa Rules of Court at sa Konstitusyon, syempre. Number 17, freedom from being compelled to be a witness against oneself or for being forced to confess guilt or from being induced by a promise of immunity or reward to make such confession, except when a person confessing becomes a state witness, maliban na lamang doon. Number 18, freedom from excessive fines or cruel and unusual punishment unless the same is imposed or inflicted in accordance with the statute which has not been judicially declared unconstitutional. So, kunwari, sa traffic, masyado kang pinagmulta ng pagkalaki-laki na hindi naman talaga yun ang multa. Hindi ito naaayon sa ordinansa, hindi ito naaayon sa batas. Pwede kang magkaso ng damages laban sa mga mapanirang tao na yon. Number 19, freedom of access to the courts. In any of the cases referred to in this article, whether or not the defendant's act or omission constitutes a criminal offense, the aggrieved party has a right to commence an entirely separate and distinct civil action for damages and for other relief. Such civil action shall proceed independently of any criminal prosecution and may be proved by a preponderance of evidence. The indemnity shall include moral damages, period. Exemplary damages may also be adjudicated, o ito yung mga damages na ginagagawad, ibinibigay para mag-set ng example na huwag ka nang gumawa ng masama, kundi magbabayad ka ng ganito. The responsibility herein set forth is not demandable from a judge unless his act or omission constitutes a violation of the penal code or other penal statute. Okay. Kung may mga batas na ginagawang kriminal, kung may mga batas na ginagawang krimen, yung kunwari pag-impair mo sa kalayaan bumoto, di kulong ka pa. Pero ito yung balangkas nung basically susundan ayon sa konstitusyon tong civil code yung susundan kung paano ka kumilos o umarte dito sa ating lipunan. Ito tayo sa Article 33. In cases of defamation, fraud, and physical injuries, a civil action for damages entirely separate and distinct from the criminal action may be brought by the injured party, o nabanggit natin yan sa criminal procedure. Such civil action shall proceed independently of the criminal prosecution and shall require only a preponderance of evidence. So, ilang beses na nabanggit dito. Kahit na na-dismiss ang isang kasong kriminal, pwede ka pa rin magsampa, kunwari, ng separate civil action. At ang required lang kasi doon ay preponderance of evidence. Pwede pa rin siya maging, hindi man siya criminally liable sa'yo, civilly liable naman siya sa'yo. Okay? At lagi natin tatandaan, bawat krimen ay may kaakibat na civil na pananagutan. Article 34, when a member of a city or municipal police force refuses or fails to render aid or protection to any person in case of danger of life or property. Such peace officer, ito yung mga police, shall be primarily liable for damages, and the city or municipality shall be subsidiary responsible therefore. The civil action herein recognized shall be independent of any criminal proceedings, and the preponderance of evidence shall suffice to support such action. Article 35. When a person claiming to be injured by a criminal offense charges another with the same for which no independent civil action is granted in this code or any special law, but the justice of the peace finds no reasonable grounds to believe that a crime has been committed, or the prosecuting attorney refuses or fails to institute criminal proceedings, the complainant may bring a civil action for damages against the alleged offender. Such civil action may be supported by a preponderance of evidence. Upon the defendant's motion, the court may require the plaintiff to file a bond to indemnify the defendant in case the complaint should be found to be malicious. If during the pendency of the civil action, an information should be presented by the prosecuting attorney, the civil action shall be suspended until the termination of the criminal proceedings. Anong punta tayo sa last article ng preliminary title? Ang sabi rito, Article 36, prejudicial questions, which must be decided before any criminal prosecution may be instituted or proceeded, shall be governed by rules of court, which the Supreme Court shall promulgate and which shall not be in conflict with the provisions of this code. So itong code na ito na nakaangkla sa ating konstitusyon, sinabi niya rin dito na gumawa ka ng rules of court. So yun ang dahilan bakit inutusan niya rin yung Supreme Court na, duty nyo yan, constitutional duty nyo yan to promulgate the rules of court. Yun yung batas na sinusundan natin sa rules kung papaano tumakbo ang isang kaso sa korte. So sinasabi lang dito sa Article 36, prejudicial questions. Kailangan mo ng yung prejudicial questions shall be governed by the rules of court. Okay? O bago tayo umalis dyan, ano muna yung prejudicial questions? Para lamang alam natin. Ano ibig sabihin ng prejudicial question? O, sabi rito, wait lang naglo-loading pa. Basahin na lang muna natin ibang nakikita natin. Prejudicial question is understood in law to be that which must precede the criminal action. So dapat masagot muna itong katanungan nito bago magpatuloy ang isang criminal action. It usually involves the suspension of the proceedings in a criminal case to await the result of the civil case, since the outcome of the latter is very essential to the former. So may kaso ang kinakaharap pero may prejudicial question na muna. So isinususpindi muna yung proceeding o yung paglilitis sa criminal case at hinihintay muna natin yung outcome nung lumabas sa civil case, kasi yung kalalabasan nito ay very essential, sabi niya, doon sa criminal case. Okay? So alam na natin kung ano yung prejudicial question na yan. At kung paano resolbahin yan ay alinsunod sa rules of court of the Philippines. Okay? Magpapahinga lang ako at susubukan ko pang balikan. Baka kaya ko pang magbasa. Okay? Yung Book 1. After ng preliminary title po kasi merong Book 1, isang katerbang mga title yan, nakalagay, iba-iba yung tinatalakay sa Book 1. Book 2, iba-iba na naman yung tinatalakay. So, subukan nating balikan yung Book 1. Okay, wait lang. Hello, so ako muling nagbabalik. Subukan nating basahin ang Book 1 ng Civil Code. Okay, kaso nag-load ang aking Civil Code app. Civil Code app lang kasi ang binabasa ko. Okay, wala akong libro, mahal. Okay, basahin natin yung Title 1 ng Book 1. Title 1 of Book 1 ng Civil Code na pinamagatang Civil Personality. Sabi rito, nagsisimula siya sa Article 37. Sabi rito, juridical capacity, which is the fitness to be the subject of legal relations, is inherent in every natural person and is only lost through death. Okay? Juridical capacity, inherent daw yan sa bawat tao. Okay? Capacity to act, which is the power to do acts with legal effect, is required and may be lost. Okay? Is acquired and may be lost. So, yung juridical capacity, inherent yan sa bawat isa sa atin. Pero yung capacity to act ay nakukuha lamang at maaari ring mawala sa iyo. Article 38, minority, insanity, or imbecility, the state of being a deaf, mute, prodigality, and civil interdiction are mere restrictions on capacity to act. Restriction lamang ito, and do not exempt the incapacitated person from certain obligations as when the latter arise from his acts or from property relations such as easements. Okay, so yung minority, insanity, imbecility, yung state of being a deaf, mute, ganyan, prodigality, and civil interdiction, restriction lamang ito. Hindi ka nito tinatanggalan ng capacity to act at hindi ka rin exempted sa mga pwedeng maging dulot ng iyong mga obligasyon sa batas. Article 39. The following circumstances, among others, modify or limit capacity to act. Ito yun. Age, okay, kung ikaw ay minor pa, insanity, imbecility, the state of being a deaf mute, penalty, yung meron kang nilabag sa batas at pinagbabayaran mo ito, prodigality, family relations, alienage, absence, insolvency, kawalan ng pera, and trusteeship. The consequences of the circumstances are governed in this code, other codes, sabi nila, yung rules of court, and in special laws. So, laging ang mga laws ay, yung mga code na binabasa natin, lagi silang in harmony with one another. At yung mga special laws na sinasabi, ito yung mga RA. Okay? RA something, gano'n. Capacity to act is not limited on account of religious belief or political opinion. Hindi dapat na haharangan ng iyong religious belief or political opinion yung iyong capacity to act. Hindi siya nililimitahan ito. A married woman, 21 years of age or over, is qualified for all acts of civil life, except in cases specified by law. Okay? At na tayo sa Chapter 2, Natural Persons, Article 40, Title 1 pa rin of Civil Code. Sabi rito, birth determines personality, but the conceived child shall be considered born for all purposes that are favorable to it, provided it be born later with the conditions specified in the following article. Okay? So yung pinagbubuntis mo pa lamang na bata ay kinukonsidera na ng batas na ipinanganak na sa lahat ng purposes na favorable doon sa batang iyon. Article 41. For civil purposes, the fetus is considered born if it is alive at the time it is completely delivered from the mother's womb. However, if the fetus had an intrauterine life of less than 7 months, it is not deemed born if it dies within 24 hours after its complete delivery from the maternal womb. So kung nagkaroon daw ng intrauterine life na mas mababa sa 7 months, hindi ito considered na ipinanganak kahit na i-deliver mo ito, na ipanganak siya pero namatay siya after 24 hours. Article 42, civil personality is extinguished by death. The effect of death upon the rights and obligations of the deceased is determined by law, by contract, and by will. So pinakamaganda yung mamamatay ka sa mundong ito nang wala ka sanang pinagkakautangan. Diba? Lalo na kung wala kang ari-arian, sus Mariosep, kawawa mga anak mo. Article 43, if there is a doubt as between two or more persons who are called to succeed each other, as to which of them died first, Whoever alleges the death of one prior to others shall prove the same. In the absence of proof, it is presumed that they died at the same time, and there shall be no transmission of rights from one to the other. Nakalagay rin to, alam ko, sa Rules of Court. Chapter 3, Juridical Persons. Ito, simulan natin yung Chapter 3, Title 1 na ng Civil Code. Sa Article 44, the following are juridical persons. Number 1, the state and its political subdivisions. So yung gobyerno natin, yung gobyerno ng Pilipinas at ang mga local governments. Number 2, other corporations, institutions, and entities for public interest or purpose created by law. Their personality begins as soon as they have been constituted according to law. Number 3, corporations, partnerships, and associations for private interest or purpose to which the law grants a juridical personality separate and distinct from that of each shareholder, member, or partner. Article 45, juridical persons mentioned in numbers 1 and 2 of the preceding article are governed by the laws creating or recognizing them. Private corporations are regulated by laws of general application on the subject. Partnerships and associations for private interest or purpose are governed by the provisions of this code concerning partnerships. Wait lang ha. So, doon sa nagdaang section na binasa natin, sinasabi niya lamang noon na merong juridical personality o yung karapatan na pumasok sa mga legal relations. Yung estado, yung gobyerno natin, yung mga korporasyon at syempre tayong mga tao. Okay? Article 46, juridical persons may acquire and possess property of all kinds as well as incur obligations and bring civil or criminal actions in conformity with the laws and regulations of their organization. Article 47. Upon the dissolution of corporations, institutions, and other entities for public interest or purpose mentioned in number 2 of Article 44, their property and other assets shall be disposed in pursuance of law or the charter creating them. Okay, bigyan na lang ako ng halimbawa. Kunwari, na-dissolve ang isang korporasyon, meron siyang mga pag-aari. So, meron mga may pinagkakautangan siya. So, pwedeng mapunta yun by law, okay, sa mga pinagkakautangan niya pag pinagdesisyonan ng korte at iba pa. Okay? O depende sa charter na nag-create sa kanila, yung batas na nag-create doon sa korporasyon o institusyon na yon. If nothing has been specified on this point, the property and other assets shall be applied to similar purposes for the benefit of the region, province, city, or municipality, which during the existence of the institution derived the principal benefits from the same. Okay? Siyempre, nung nabubuhay yung korporasyon na yun, yung nakuha niya, yung benepisyo niya doon sa mga munisipalidad, region, or province na yun. So, pag na-dissolve ang isang korporasyon, tama lamang din na pakinabangan ng mga publiko yung kanya may iwan. Yun kung wala siyang pinagkakautangan, okay? O yun kung walang nakasulat sa kanyang batas, doon sa kanyang charter na bumubuo sa kanya na upon dissolution, dito mapupunta ang mga pag-aari nito. Ganon. Punta naman tayo sa Title 2, Citizenship and Domicile. Okay, Title 2, Book 1 ng Civil Code of the Philippines. Article 48, the following are citizens of the Philippines. Number 1, those who were citizens of the Philippines at the time of the adoption of the Constitution of the Philippines. So sino ba yung mga Philippine citizens nung inadopt yung Constitution natin, 1987 Constitution natin? Sila ang citizens. Number 2, those born in the Philippines of foreign parents who, before the adoption of said Constitution, had been elected to public office in the Philippines. Kaya makakita kayo, mayroong mga politikong puti or what. Example na natin siguro sila Richard Gordon na yung mga magulang niya ay na-elect sa pwesto bago pa i-adopt ang said Constitution. Number 3, those whose fathers are citizens of the Philippines. Number 4, those whose mothers are citizens of the Philippines and upon reaching the age of majority elect Philippine citizenship. Number 5, those who are naturalized in accordance with the law. Okay? Article 49, naturalization and the loss and reacquisition of citizenship of the Philippines are governed by special laws. Okay, kaya example natin kunwari na lamang yung naturalization ng isang dayuhan, foreign basketball player na gusto nating i-naturalize para mapakinabangan natin sa Gilas, Pilipinas, sa basketball team natin. So they are governed by special laws. Ang gagawin ng Kongreso niyan, RA something something, maglalabas sila ng batas, RA something something na binibigyan ng naturalization, nina-naturalize nila yung dayuhan na yun. So isang example lamang yun ng naturalization governed by special laws. Article 50. For the exercise of civil rights and the fulfillment of civil obligations, the domicile of natural persons is the place of their habitual residence. Sabi lamang dito, for the exercise ng iyong civil rights and the fulfillment of civil obligations, the domicile o yung lugar, yung iyong tahanan of natural persons is a place of their habitual residence. Okay, ito yung para sa maraming bahay. Article 51. When the law creating or recognizing them or any other provision does not fix the domicile of juridical persons, the same shall be understood to be the place where their legal representation is established or where they exercise their principal functions. So, example ng isang juridical person ay ang isang korporasyon. So, kung yung charter nila, yung batas na kumikilala sa kanila, hindi nakasya doon kung saan ba talaga yung domicile ng korporasyon na yun. Sabi dito, it shall be understood to be the place kung saan sila saan ang kanilang legal representation and where their principal functions is being exercised. Yun ang sabi. Ngayon, magtungo naman tayo sa Title 3 of Book 1 ng Civil Code, yung marriage. Ito, repealed na ito eh. Sabi rito pero basahin pa rin. Meron na kasing persons and family relations. So, basahin pa rin natin tong marriage, no? Baka naman bago na ito. Basta itong mga binabasa ko yung nasa lumang civil code at lagi nating tatandaan na maaaring may mga batas na naipasa na in effect na nagsusupersede na sa mga binabasa natin, okay? Title 3, Marriage. Chapter 1, Requisites of Marriage. Sabi rito sa Article 52, marriage is not a mere contract but an inviolable social institution. Hindi lang siya kontrata. Its nature, consequences, and incidents are governed by law and not subject to stipulation except that the marriage settlements may, to a certain extent, fix the property relations during the marriage. O bakit naman pinapayagan ito ng batas? Yung property stipulation, yung in layman's term, prenup. Yan. Kasi baka naman maagrabyado yung isang masyadong mayaman, ikinasal siya sa hindi masyadong mayaman, kailangan ding tignan ng batas na pangalagaan yung pag-aari ng kanilang pamilya. Tungo tayo sa Article 53. No marriage shall be solemnized unless all these requisites are complied with. Sandali lang, tumatahol yung mga aso. Wait lang. Okay, so mabalik tayo dahil naging ngayon aking mga aso dahil sa pagdating ng aking tita. Okay, Article 53, mabalik tayo. No marriage shall be solemnized unless all these requisites are complied with. Ito yung essential requisites ng isang valid marriage. Dapat sama-sama ito. Number 1, legal capacity of the contracting parties. Hindi ka baliw, hindi ka minor, etc. Number 2, their consent is freely given. Hindi ka shotgun wedding, yung tinutukan ka ng baril kaya ka nagpakasal. Number 3, authority of the person performing the marriage. Hindi naman pwedeng basta ikasal kita, wala naman akong authority. Di ba? Yung mga pastor, pari, nangunguha rin sila ng authority to contract marriage. Meron silang lisensya para mag-conduct ng marriage at yung mga mayor. Number 4, a marriage license except in a marriage of exceptional character. So, okay, kailangan dito meron kang marriage license. Pero, sa pagkakatanda ko lamang dito sa except in marriage of exceptional character, kung hindi ako nagkakamali, yung mga 5 years nang nagsasama bilang mag-asawa na kasal na lamang ang kulang, pero nagsasama na sila bilang mag-asawa sa loob ng 5 taon, ay exempted na yata, kung hindi ako nagkakamali, na kumuha ng marriage license. So, yun ang 4 na requisites ng isang valid marriage. Article 54, any male of the age of 16 years or upwards and any female of age of 14 years or upwards not under any of the impediments mentioned in the articles 80 may contract. Mali na yata ito, hindi na yata ito yun. Ang alam ko 18 years old na ito. Alam ko 18 years old or hindi ko alam kung may bagong batas, basta 18, okay? Yun nga lamang, baka itong provision ng Article 54 applies na lamang sa mga tribal groups o yung mga pwede nilang patunayan na according sa customs nila, kahit na mas bata pa yung edad, pwede na ikasal. Okay, sa kanila na lang nag-a-apply ito, hindi na siya pangkalahatan. Article 55, no particular form of the ceremony of marriage is required. Actually, binabasa lang natin siya lahat, pero baka nga na-supersede na ito ng persons and family relations, okay? Basahin na lang natin. No particular form for the ceremony of marriage is required, but the parties with legal capacity to contract marriage must declare in the presence of the person solemnizing the marriage and of 2 witnesses of legal age that they take each other as husband and wife. This declaration shall be set forth in an instrument in triplicate, signed by signature of mark by the contracting parties and said 2 witnesses and attested by the person solemnizing the marriage. In case of a marriage on the point of death, when the dying party being physically unable cannot sign the instrument by signature or mark, it shall be sufficient for one of the witnesses to the marriage to sign in his name, with fact shall be attested by the minister solemnizing the marriage. Ito yung mga kinakasal. Artikulo mortis. Yun ba yung tamang tawag doon? Or at the point of death, para siyang dying declaration of love at dying declaration ng kagustuhan na ipakasalan ng isang tao, valid na yun. Okay. Article, pero ano pa rin, ang kailangan pa rin nito, may witness. Pwede daw hindi na siya ang pumirma. Yun lang naman ang sinasabi rin. Article 56, marriage may be solemnized by number 1, the Chief Justice and Associate Justices of the Supreme Court. Number 2, the Presiding Justice and the Justices of the Court of Appeals. Number 3, Judges of the Court of First Instance. Ayan, sure ako dyan, in judge. Number 4, mayors of cities and municipalities. Ayan, ginagamit pa rin yan ngayon kay Yorme at kay sa crush ko na si Doña Tesoro. Mayor Doña Tesoro ng province of Rizal. Number 5, municipal judges and justices of peace. Number 6, ito syempre priests, rabbis, minister of gospel of any denomination, church, religion, or sect, duly registered as provided in Article 92. Number 7, ship captains, airplane chiefs, military commanders, consuls and vice consuls in special cases provided in Articles 74 and 75. Ayan Maring may nabago na dyan, pero generally yan pa rin yata yun. Article 57, the marriage shall be solemnized publicly in the office of the judge, in open court, or of the mayor, or in the church, chapel, or temple, as the case may be, and not elsewhere, except in cases of marriages contracted on the point of death, or in remote places in accordance with Article 72 of this code, or in case of marriage referred to in Article 76, or when one of the parents or the guardian of the female or the latter herself is over 18 years of age, request in writing, in which cases the marriage may be solemnized at a house or place designated by said parent or guardian of the female, or by the latter herself in a sworn statement to that effect. So basta ang gusto lang naman sabihin dito, kailangan isa publiko yung kasal, parang ganon. Article 58, save marriages of an exceptional character authorized in Chapter 2 of this title, but not those under Article 75. No marriage shall be solemnized without a license first being issued by the local civil registrar of the municipality where either contracting party habitually resides. Article 59, sinabi ko na yan kanina. Article 59, the local civil registrar shall issue the proper license if uh, to each of the contracting parties if each of the contracting parties swears o nanumpa separately before him or before any public official authorized to administer oaths to an application in writing setting forth that such party has the necessary qualifications for contracting marriage. The applicants, their parents or guardians, shall not be required to exhibit their residence certificates in any formality in connection with the securing of the marriage license. Hindi raw kailangan yung residence certificate ng mga guardian o ng parent. Such application shall insofar as possible contain the following data. So ito yung laman ng iyong application for marriage license: full name of the contracting party, number 2, place of birth, number 3, age, date of birth, number 4, civil status, single, widower or divorced, yun. Number 5, if divorced, how and when the previous marriage was dissolved. Kung kaya't ang divorce decree sa ibang bansa, wala pa tayong divorce out of this moment sa bansang ito, pinadadala dito para kilalanin na ikaw ay divorced na. Number 6, present residence. Number 7, degree of relationship of the contracting parties. Number 8, full name of the father. Number 9, residence of the father. Number 10, full name of the mother. Number 11, residence of the mother. And number 12, full name and residence of the guardian or person having charge in case the contracting party has neither father nor mother and is under the age of 20 years if a male or 18 years if a female. Magandang proseso rin na sundan maigi yung pag-contract ng marriage, yung pag-apply ng marriage license, kasi doon mo malalaman baka naman may tinatago, baka naman hindi mo pala pwedeng pakasalan ng iyong jowa, o baka naman kaya inaalam tagasan ng ama, tagasan ng ina, ganon. Baka alam nyo na, yun. May purpose ang batas kaya dapat sinusunod. Article 60. The local civil registrar upon receiving such application shall require the exhibition of the original baptismal or birth certificates of the contracting parties or copies of such documents duly attested by the persons having custody of the originals. These certificates or certified copies of the documents required by this article need not to be sworn to and shall be exempt from the documentary stamp tax. Sana ngayon exempt pa rin, no? The signature and official title of the person issuing the certificate shall be sufficient proof of its authenticity. If either of the contracting parties is unable to produce his baptismal or birth certificate or a certified copy of either because of the destruction or loss of the original, or if it is shown by an affidavit of such party or of any other person that such baptismal or birth certificate has not yet been received through the same, though the same has been requested of the person having custody thereof, at least 15 days prior to the date of the application, such party may furnish in lieu thereof his residence certificate for the current year or any previous years to show the age stated in his application, or in the absence thereof, an instrument drawn up and sworn to before the local civil registrar concerned, or any public official authorized to solemnize marriage, period. Such instrument shall contain the sworn declaration of 2 witnesses of lawful age of either sex, setting forth the full name, profession, and residence of such contracting party and of his or her parents, if not known, and the place and date of birth of such party. The nearest of kin of the contracting parties shall be preferred as witnesses, and in their default, persons well known in the province or the locality for their honesty and good repute. Okay, pinaprefer daw ng witness ay yung next of kin mo. Okay, kung meron kang kapatid, ina, yan. Or isang tao daw na kilala na matuwid. Maganda ang reputasyon sa iyong lugar. The exhibition of baptismal or birth certificates shall not be required if the parents of the contracting parties appear personally before the local civil registrar concerned and swear to the correctness of the lawful age of said parties, as stated in the application, or when the local civil registrar shall, by merely looking at the applicants upon their personally appearing before him, be convinced that either or both of them have acquired the age. Ulitin ko, ang alam ko sa age na ito, 18. 18 na. Article 61, in case either of the contracting parties is a widowed or divorced person, the same shall be required to furnish, instead of the baptismal or birth certificate required in the last preceding article, the death certificate of the deceased spouse or the decree of the divorce court, as the case may be, period. In case the death certificate cannot be found, the party shall make an affidavit setting forth this circumstance and his or her actual civil status and the name and the date of the deceased and the name and the date of the death of the deceased spouse. Haba, no? In case either or both of the contracting parties, being neither widowed nor divorced, are less than 20 years of age as regards the male and less than 18 years as regards the female, they shall, in addition to the requirements of the preceding articles, exhibit to the local registrar the consent to their mother or of their father, mother or guardian, or persons having legal charge of them in the order mentioned. Okay, sabi lang mang dito, kung ikinakasal ay hindi naman sila widowed or divorced, ay less than 20 years of age. Ang lalaki ay basta hindi pwede ikasal ang less than 18. Basta ang sinasabi lang dito, kailangan nila ng consent. Okay. Yun na yata rin yung nakalagay sa bagong persons and family relations na siyang mangingibabaw. Kung di ako nagkakamali, okay? Kailangan ng parents' consent kung ikaw ay nasa pagitan ng 18 to 21. Parang ganun ha. Binabasa na lang natin yung nakalagay sa luma. Tuloy na rin natin kasi may mga pagkakapareho rin naman. Article 62, males above 20 but under 25 years of age, or females above 18 but under 23 years of age shall be obliged to ask their parents or guardian for advice upon the intended marriage. Ganito na lang. Para sigurado tayo, hindi ko muna babasahin lahat ng ito kasi alam ko may mga bago na. Pinakamainam na lamang na manguha tayo ng advice, yun na muna. Ilalagay ko na lamang dito kung may bago na ba sa persons and family relations. Diba? Pero binabasa ko lang ito as luma. Okay? Dahil baka mamali tayo. Baka mahirap na. Diba? Sandali lang, hanapin natin yung tignan lang natin. Check lang natin na maigi. Kasi marami ng bago eh. Okay? Okay. Okay. Ay, sauce, hindi ito. Ano ba yan? Okay, hanapin lang natin. Wait lang ha. Persons and Family Relations Law. O saka na natin hanapin yan. Hindi ko mahanap ngayon eh. Basahin na muna natin. Tuloy na lang muna natin basahin yung civil code na luma. But just keep in mind na maaaring meron ng mga pagbabago rito. Okay. Ito yung Title 3 eh. Okay, basahin na muna natin yung void and voidable marriages. Okay. Ay, hindi. May pagbabago na nga eh. Okay, so ganito. Stop na muna tayo rito. So, magtatapos tayo sa Title 2. Okay. Sabihin na natin na sigurado tayo sa mga sinabi natin dito hanggang Article 51. So, ang binasa natin po ngayon ay yung preliminary title. Nagabalikan natin yung preliminary title. Tapos nagtungo tayo sa Book 1, Title 1 to Title 2, which is yung Title 1 is Civil Personality, yung Title 2 is the Citizenship and Domicile hanggang Article 51. Yun na muna yung sabihin natin, sure tayo para saka na natin ituloy basahin. Okay? Okay. Mahaba yung persons and family relations. Okay, so doon muna tayo magtatapos. Sana po ay marami kayong natutunan. At God bless sa inyong lahat. Ako po ay muli magbabalik para magbasa na naman ng mga batas. At hopefully maipaliwanag natin ito pare-pareho in layman's terms. Nagtatapos tayo muli. Article 51, Title 2 of Book 1 of the Civil Code. Goodbye.